My name is Emyr Thomas. I'm a partner and parliamentary agent, and I will summarise the key provisions of the EU Withdrawal Bill. In this podcast, I will talk about the general effect of the bill, the retention of EU law which will not be retained, the relationship between the UK courts and the European Court of Justice, Henry VIII powers, and devolution. The bill will repeal the European Communities Act 1972 on the day the United Kingdom leaves the European Union. Termed Exit Day in the bill, it is currently scheduled to take place on Friday the 29th of March 2019 at 11 p.m, which will be midnight in Brussels. This marks the time at which, under the terms of Article 50 of the Treaty on the European Union, the UK will cease to be an EU member state, unless the UK and EU have already concluded a withdrawal agreement which specifies a different departure date. The constitutional consequences arising from the bill are enormous, since it ends both the supremacy of EU law in the UK and removes the processes by which EU law becomes part of a UK law. To ease the transition and ensure legal certainty post-Brexit, the bill provides for the continued application of EU law in force and applicable to the UK before our official departure. The bill deals with how EU law would be preserved in or converted into domestic law at the point of exit day, and what status this new category of retained EU law would have after exit day. By Section 2.1 of the 1972 Act, certain types of EU legislation which are directly applicable, such as EU regulations, are automatically incorporated into UK law and bind our courts and tribunals without Parliament having to pass implementing legislation. To prevent EU legislation incorporated in this way ceasing to have effect when we leave the EU, the bill provides that direct EU legislation, which includes any EU decision, regulation or tertiary legislation, which is operative immediately before exit day, will form part of domestic legislation on and after that day. By Section 2.2 of the 1972 Act, EU law which is neither directly applicable nor has direct effect, such as an EU directive, can be given effect in UK law by secondary legislation. Unless expressly saved, secondary legislation usually expires when the primary legislation under which it is made has been repealed. The bill therefore provides that such EU-derived domestic legislation which has effect in UK law immediately before exit day will continue to have effect in UK law when the 1972 Act is repealed and afterwards. While the bill provides for the continuity of much of EU law in the UK on and after exit day, a notable exception is the Charter of Fundamental Rights. The Charter brings together in a single document the fundamental rights protected in the EU. And when the UK acts within the scope of EU law, it must do so compatibly with the Charter. And any UK primary legislation which conflicts with the directly effective right under the Charter must be set aside if it cannot be read compatibly with it. The bill provides that the Charter will not form part of domestic law on or after exit day. However, this will not affect the retention in domestic law of any fundamental rights or principles which exist irrespective of the Charter. It also provides that the references to the Charter in any case law are to be read as if they were references to any corresponding retained fundamental rights or principles. While these rights or principles are not defined, they are presumably rights and principles set out in retained EU law and other human rights treaties which are applicable in the UK and which are captured by the Charter. The European Court of Justice is the judicial institution of the EU. The bill provides that EU decisions made post-Brexit will not bind domestic courts, that domestic courts cannot refer cases to the European Court of Justice after exit day, and that while a domestic court will not be required to have regard to anything done on or after exit day by the European Court of Justice, it may do so if it considers appropriate. This would allow the UK courts to have regard to post-exit ECJ case law, but would not oblige them to do so. Given this discretion, it is difficult to anticipate what approach the courts will adopt when interpreting EU law. The bill allows ministers to make regulations to prevent, remedy or mitigate any failure or deficiency in any retained EU law which arise from the UK's withdrawal from the EU. More strikingly, these regulations may make any provision that could be made by an Act of Parliament. The power to amend primary legislation by using secondary legislation is known as the Henry VIII power, and the inclusion of the power in the bill is one of its most controversial aspects because of the limited scrutiny to which secondary legislation is subject compared with primary legislation. The power to make regulations is not unconstrained. It is limited by time, expiring after 2 years, and subject matter. For instance, the regulations cannot impose or increase taxation, create criminal offences for which an individual can be imprisoned for more than 2 years, or amend, repeal, or revoke the Human Rights Act. Despite this, the power is wide-ranging. For instance, while regulations will be used to perform a technical purpose, such as correcting EU references that are no longer appropriate, they may also be used to create UK public authorities to do things previously done by EU institutions and to transfer EU functions to the new authority. The devolved legislatures of Northern Ireland, Scotland and Wales cannot currently legislate in a way which is incompatible with EU law. The bill changes this so that after exit day, the devolved legislatures will not be able to legislate contrary to retained EU law. Constitutionally, this is a significant change. Presently, the restriction is based on the devolved legislatures being part of an EU member state. But after Brexit, the restriction will be based on an act made by the UK Parliament. The purpose behind the devolution provision seems to be to prevent the grant of further powers to the devolved legislatures via Brexit, and to ensure that legislating for Brexit is carried out in a centralised fashion. While this might be administratively convenient for the UK government, it is perhaps surprising that areas of EU law which fall within the competence of the devolved legislatures will not be domesticated by those bodies. Unsurprisingly, the devolved administrations in Cardiff and Edinburgh opposed the devolution provisions in their original form, and it is expected that the government will bring forward amendments to deal with their concerns. At the time of recording this podcast, the bill has completed all of its stages in the House of Commons and now awaits report stage in the House of Lords. The Lords will probably conclude their considerations of the bill by May before sending any proposed amendments to the Commons. If this timetable is adhered to, the bill should receive royal assent by the summer recess, which begins on the 24th of July. Should you have any questions, please don't hesitate to contact me at the address shown on the screen.